Here are 10 prohibited activities for anyone entering the United States with a B1 visa, B2 visa, or ESTA under the Visa Waiver Program. Engaging in these activities can lead to denial of entry, removal, visa revocation, and or future ineligibility for U.S. visas. Number 5 is the trickiest, so wait for it. Number 1, engaging in productive work or employment. Performing skilled or unskilled labor, hands-on work, or any activity that benefits a U.S.-based company and could be performed by a U.S. worker is prohibited. This includes working as a consultant, freelancer, contractor, or employee for a U.S. client, for example, even if you're paid by a foreign entity. 2, receiving salary or remuneration from a U.S. source. Receipt of wages, salary, or direct payment from a U.S. entity for services performed in the U.S. is prohibited, except for reimbursement of incidental expenses such as travel or lodging, or limited academic honoraria under strict conditions. 3, managing daily business operations. Acting as a CEO, manager, or employee, overseeing daily operations, hiring, firing staff, or performing managerial tasks for a U.S. business is prohibited. While B1 visa holders may engage in limited business activities such as attending meetings, conferences, negotiating contracts, or conducting market research, hands-on management crosses into unauthorized work, which is why founders or executives typically require visas like the E2 or O1A. 4, building or construction work. Performing hands-on construction or building work, even if required by a foreign contract, is prohibited. And 5, remote work for foreign employers. In general, performing remote work for a foreign employer while physically in the United States is considered unauthorized and therefore prohibited, as it may be interpreted as productive work. Unfortunately, the legality of remote work for a foreign employer while in the U.S. on a B1, B2, or ESTA is a bit gray and confusing, and I've seen this cause big problems for some good people. So remember this: CBP may interpret your remote work for a foreign employer in the U.S. as unauthorized if it resembles productive work performed on U.S. soil. For example, a digital nomad working full-time for a foreign employer while in the U.S. risks scrutiny, especially if the stay is prolonged or frequent, and CBP officers have discretion to deny entry if they suspect intent to work. It's true that some individuals engage in remote work for a foreign employer in the U.S. without issue. That is, they get away with it. But you're taking a big risk doing it yourself and would be well advised to get a proper work or investor visa, such as an O1 or E2, instead. 6, performing paid services for U.S. clients. Freelancers, consultants, or contractors cannot perform services for U.S.-based clients, even if payment is processed abroad. The focus is on the location of the work performed, not the payment source. 7, participating in hands-on internships or training. Engaging in unpaid internships or training programs that involve practical hands-on work is not permitted. 8, conducting personal business for profit. Engaging in personal business activities for profit, such as selling goods, running a side hustle, or assisting in a family business in the U.S. is not permitted. 9, professional performances by entertainers. Professional entertainers cannot perform in the U.S. even if unpaid unless they qualify as amateurs receiving only incidental expenses. Paid or unpaid professional performances require visas like the O1 or P1, and CBP has increased scrutiny for social media influencers because their activities, such as creating sponsored content, may be deemed work. I've seen that happen. And 10, studying or enrolling in academic programs. Enrolling in a school, university, or academic study program for credit requires an F1 visa. So what can you do? Well, in general, B1 visas allow activities like attending business meetings and conferences or negotiating contracts, while B2 visas cover tourism, visiting family, or medical treatment. And ESTAs permit similar activities under the Visa Waiver Program. But any activity resembling work or study outside of these categories risks violation. So please ensure that your planned activities in the United States align with permitted categories. Seek legal advice if you're uncertain. And for longer stays or work-related activities, consider work visas like the O1 or investor visas like the E2. I'm Joseph Bovino, U.S. Immigration and Business Attorney based in Miami and serving clients worldwide. Use the link in my bio if you'd like to schedule a consultation and follow for more.